Good morning, everyone. Happy Friday. It's October the 3rd. Welcome to this Committee of the Whole meeting for the Thompson-Nicola Regional District. The TNRD acknowledges that we connect with many First Nations communities across our vast regional district. Today, we are located in the Tecumlip-Secwepemc territory, situated within the unceded ancestral lands of the Secwepemc Nation. The TNRD appreciates the partnership that we have with Tecumlip-Secwepemc, and we respect the territory and land on which we gather today. We have the Committee of the Whole meeting minutes from June 27th. Director Middleton, thank you. Seconded by Director Karpuk, thank you. Are there any errors or omissions? Seeing none, all those in favor? Opposed, if any? That is carried. Moving right along to item 4.1, we have a presentation, Proposed Code of Conduct Bylaw. We have a presentation from General Manager of Corporate Services, and we have Denise McCabe from Fulton & Co. here to provide a presentation. And if you could hold any questions until the end of the presentation, that would be awesome. Without further ado, over to whomever is going first.
Thank you, Chair, members of the board. As stated, my name is Denise McCabe. Many of you I know. I'm also have with me today Kaylee Treisman, my associate. We're going to be sharing the presentation back and forth. Let's just start. So today we're going to be walking you through the proposed new code of conduct bylaw that will be coming to you for consideration. And a new code was required. Some of you may be asking, why are we here? Why are we doing this? A new code was required because of issues with the previous code that rendered certain provisions regarding enforceability and procedural fairness a little problematic. And in addition, it didn't really spell out the expectations of board members of each other as a traditional code of conduct does. So today we're going to go through the code of conduct, talk about things like who does the code apply to, what are the standards that each member expects of each other, the complaint process, available sanctions that this board can impose, consequences for non-compliance with those sanctions, prohibition on interference with the investigation, public disclosure requirements, and reimbursement of legal fees. So turning to, as a starting point, who does this code of conduct apply to? It applies to both board members and board committee members. And the reason that the bylaw has been designed to include committee members is because committee members who are not board members are not bound by the confidentiality or conflict provisions in the community charter and the Local Government Act by reason of the community charter. By including committee members in this bylaw, we can require them to abide by the confidentiality and conflict provisions. It's important to note that the bylaw does not apply to TNRD staff or non-member committee volunteers, meaning one cannot file a complaint against staff under this code of conduct or against volunteers under this code of conduct. Staff are already subject to different laws and their own code of conduct standards, policies, procedures to which they must adhere.
So now that we've talked a little bit about who this code of conduct would apply to, let's talk about the standards of conduct that are set out in the code. So for ease of this conversation and this presentation, we've grouped these standards of conduct that are set out in the code into 3 separate categories. And the first one is interactions. And so these are interactions with the public, with staff, with media, and in meetings. The next grouping is confidentiality with respect to information and records. And the final is use of power. And this includes things like conflicts of interest and abuse of office issues. Before I go through each of these categories, we just want to reiterate that the vast majority of these standards of conduct are fairly standard across all local governments in BC and across Canada. So there's nothing in here that is a significant departure from what other local governments are doing. So let's start with the category that we've grouped under interactions. So first, the Code of Conduct bylaw sets out certain general conduct requirements. So again, these are fairly standard across most local governments in BC and Canada. And this includes the requirement that members follow the requirements in this bylaw, other TNRD bylaws and policies, and other BC and Canadian laws. This also includes the requirement that board members not bully, harass, or defame other members, staff, or volunteers. And basically, the general conduct provisions of this bylaw come down to treating everyone that you encounter with respect and dignity. Next, under this sort of grouping, we have standards of conduct with respect to interactions between board members and staff, volunteers, other members, and members of the public. And so this bylaw sets out that board members should direct their inquiries regarding departmental issues or questions to the CAO or to the director of the appropriate department. Board members should avoid contacting staff directly unless the communication is minor, and they should instead direct their questions to the appropriate department director. And similarly, board members should not interfere with staff or other members in the performance of their roles and duties. And specifically, board members should not interfere with the CAO, the corporate officer, the general manager of corporate services, or an investigator that has been appointed under this bylaw when they're executing the duties under this bylaw in particular. Board members should also not request that staff undertake personal or private work for themselves or for their family. And board members should also similarly not compel staff to engage in partisan political activities. There's also requirements about sort of public-facing interactions, and so board members should not share on social media or otherwise personal information belonging to TNRD staff or other members or their families. And also set out in this Code of Conduct bylaw would be a requirement that board members not make statements attacking other members, members of staff, or their families. So continuing on with this theme of interactions with the public and media, the expected standard of conduct set out in this bylaw also says that board members must not communicate on behalf of the TNRD unless they are authorized to do so under a TNRD policy, a board resolution, or by virtue of a position or role that the board has authorized the member to undertake. And this is set out in legislation, right? Each member of the board is responsible for reflecting the will of the board. Board members should also ensure that their communications related to the TNRD board or committee business must be accurate, and they should not issue or allow to be issued on their behalf any communication the member knows or ought to know is false or misleading. And similarly, board members should not instruct procurement proponents, contractors, or consultants unless they are authorized to do so. Continuing on this interaction theme, we have a requirement that board members act with decorum at board and committee meetings and hearings and in accordance with the Board of Directors procedure bylaw. Board members would also be responsible for regularly monitoring their social media accounts and taking measures to remove any comments, messages, or posts that violate the standards of conduct set out in this bylaw, regardless of whether those comments, posts, or messages were made by the board member or another person. So that concludes sort of the interactions heading of the standards of conduct that are set out in this bylaw. So now I want to move to this confidentiality grouping and the standards of conduct with respect to confidentiality. So board members must comply with the Freedom of Information and Protection of Privacy Act and all TNRD policies. Board members must also comply with Section 117 of the Community Charter, which includes by protecting and not disclosing confidential information. And confidential information in this regard includes information and records held in confidence by the TNRD, but it also applies with respect to information and records from closed board meetings until they have been publicly released by the board. Board members should also only access information held by the TNRD for TNRD business, not personal purposes. And board members must not alter, destroy, or conceal TNRD records unless they have been expressly authorized to do so by the board in accordance with applicable laws. So on this next slide, we've set out a couple good rules of thumb when it comes to confidentiality, and these are to comply with the standards set out in this bylaw. So if it was discussed and closed, it remains confidential until the board officially releases the information from closed. It remains confidential despite any public discussion about the topic, and it can only be released from closed by virtue of a board resolution to do so. The board as a whole makes decisions about what stays in or is released from closed. So there will be information and records that are discussed in closed and are never released into open. Similarly, there will be information and records that are discussed in closed and are immediately released into open. So the bottom line is if there has not been a board resolution to release it from closed, it remains confidential. And this next slide here also sets out some good rules of thumb about what this bylaw permits board members to discuss. And this slide sets out what can and cannot be discussed. So you may not discuss information that is still enclosed, that hasn't been officially released by a board resolution, personal information about TNRD staff, matters on which you may have a conflict of interest, whether you have declared that conflict or not, and privileged information. So anything we come to talk to you about. Conversely, board members can discuss information that has been officially released from closed, information that was lawfully discussed in open meeting, and information that the board directs you to discuss. So now moving on to this third grouping of standards of conduct under the bylaw, which is this use of power grouping. As elected officials, you're given significant power and entrusted to use that power for the good of the district. And there are a variety of checks and balances that ensure that you don't abuse the power that's been given to you by the electorate. And these checks and balances are, of course, set out in the Community Charter and the Local Government Act, but they are also reinforced by this Code of Conduct bylaw. So there are some provisions in this bylaw that talk about use of power in terms of improper use of influence. So there's the requirement that board members only use the influence of their office in the exercise of their official duties. Board members cannot use their office to intimidate, improperly influence, threaten, or coerce others. And board members are not permitted to attempt in any way to influence a decision, action, or action inside the TNRD, for example, by the board, by a committee, by an officer or staff member, or a decision outside the TNRD by another governing body, if the member has a pecuniary interest in that matter. That would constitute a conflict of interest. Board members cannot use their office to provide preferential treatment to any person or organization, except as warranted by the ordinary and lawful discharge of their duties. This bylaw also sets out conflict of interest provisions, so board members should avoid situations which may result in claims of conflict of interest, other pecuniary interest, or bias. And that's some particular language there. Avoid situations which may result in claims of conflict of interest, other pecuniary interest, or bias. And this means that board members must not act while under a conflict, but also must not act in circumstances of perceived conflict or bias. This is especially true when the board is acting in its quasi-judicial role. The board must be and be seen to be impartial in those matters. Board members must follow the rules set out in the Community Charter with respect to disclosing conflicts and refraining from participating when they have a conflict. And board members must, for every matter that comes before the board, assess whether they have a conflict and determine whether it's necessary to seek independent legal advice with respect to that conflict. And if a member believes they have a conflict, the member must notify the person presiding as chair that they have a conflict and refrain from publicly or privately discussing the matter with any other member before, during, or after the meeting or about that matter. In this use of power category, we also have standards of conduct with respect to the employment of board family members. So board members must not attempt to influence decisions regarding the hiring, transfer of, promotion, demotion, discipline, suspension, or termination of potential or existing staff or volunteers. And this prohibition includes a prohibition on giving a reference for a person applying for a position at the TNRD or forwarding copies of a person's resume to someone who is hiring for a position at the TNRD. Members similarly should not attempt to obtain benefits from the district for themselves, their family members, their friends, or their business relations. There's also some requirements under this bylaw with respect to accepting gifts or personal benefits. So board members should not accept gifts and personal benefits except as permitted by the community charter. So you're not allowed to accept gifts connected with your office unless they are incident of normal protocol, their compensation,
Like socks.
or they are a lawful election contribution.
I got you.
Members must also disclose gifts and personal benefits in accordance with the community charter. So you must disclose any allowable gift that exceeds $250 from one source, directly or indirectly, in any 12-month period. Continuing on this use of power heading, we have an obligation in here that board members who work in another profession or business while holding office do not allow that business activity to materially affect their integrity, independence, or competence. Similarly, board members cannot use TNRD facilities, equipment, supplies, or services for any election-related activities. And board members cannot use the services of staff for election-related purposes during staff's working hours. Board members must comply with all applicable election legislation, including the Community Charter and the Local Elections Campaign Financing Act.
Thank you, Kaylee. Now we're going to turn to an overview of the complaint process. And those of you who sit on municipal councils, some of you will be more familiar than others with code of conduct complaint processes. Again, these are quite standard across those local governments in British Columbia that have codes of conduct, and indeed across Canadian jurisdictions. The complaint process is designed to preserve the integrity of the investigation and the sanctioning process. And we'll get into the details of that. So step one, a complaint is filed. It's important to note that when you file a complaint as a member of the board, it is your responsibility to provide sufficient evidence for the investigator who is reviewing the complaint to understand what the complaint is, know the investigation that must be undertaken, et cetera. So complaints should be typed, computer, and provided on the appropriate form, and see the corporate officer for the form. Complaints should also be detailed, as I said, enough for the investigator to know what it is they're actually investigating. So think who, what, where, when, and provide that level of information to the investigator. The complaint should also provide the evidence of their complaint that they want the investigator to consider. Now, it doesn't have to be down to a granular level, but if you're, for instance, using as evidence the fact that statements were made in an open board meeting that were inappropriate, then give the date of the board meeting, the general gist of what was said, and why it is you think that that statement was inappropriate. You don't need to be a lawyer to file these. They don't need to be that technical. It's just simply enough evidence or statements that the investigator knows what it is they're doing in this complaint. And as I said, it's up to the complainant to give the investigator any supporting documents, emails, et cetera, that they would like the investigator to consider. So I keep going to turn my microphone off instead of this. So complaint process step 2, once the complaint is filed, staff will initially conduct a preliminary assessment of that. If the complaint is on its face, obviously frivolous, vexatious, made in bad faith, then staff will set a time for the board to consider the complaint. And if the board agrees, if the board considers this complaint to be frivolous or vexatious or made in bad faith, then the board may reject the complaint out of hand. Now, it's important to note that it's not a standard saying, well, we don't think that complaint will succeed. It must truly be vexatious, outside the scope of the code of conduct. Somebody complaining that a board member was speeding, for instance, that's just not something that a code of conduct is designed to address. or somebody complaining about frivolous engagement they have with another board member. Those are things that are not really supposed to be subject of a code of conduct. And that's why we have an off-ramp very early in the process to ensure that the TNRD doesn't have to incur a bunch of expenses, investigation expenses for silly complaints that shouldn't really go anywhere. As I said, this is the first off-ramp. We also note in the previous iteration of the code of conduct, it had staff having a more involved role in the complaint process. So doing some mediation, trying to make some decisions, et cetera. And that's just not appropriate. The law of codes of conduct is evolving quite rapidly in British Columbia and across Canada as they become more mandatory in more jurisdictions. So the more codes of conduct there are, the more complaints there are, the more judicial challenges there are, and the more court decisions we get. And so that law evolves. And as the law evolves, the codes of conduct must also evolve with them. And so at one point, years ago, it was thought that, well, maybe we should save money. We should have staff investigate these complaints. Now, if you think it through, that's wholly inappropriate. Ultimately, staff report to the board that you can't have staff investigating or making decisions with respect to elected officials. And hence the process that we're going through here. I did it again. So step 3, once the complaint is referred to an investigator, and the investigator will conduct a preliminary assessment. The investigator has a broader authority to decline to investigate. So again, if they think that the complaint does not relate to a matter that's covered by the code of conduct, or a complaint would be better addressed in another forum, for instance, the Office of the Information and Privacy Commissioner, perhaps the RCMP if the complaint is criminal in nature, then the investigator can decline to investigate and can refer the matter to that other body. Likewise, if the investigator determines that this is just frivolous or vexatious, or the complaint is not made in good faith, meaning it's made for improper purposes, then the investigator can close the complaint. So this is the second off-ramp that's built in to avoid unnecessary costs and having to hire investigators at the expense of the TNRT to investigate things that really shouldn't go any further. The investigator can also refer the matter to informal resolution. So if they're quite minor, if it's, for instance, board interactions with each other, then mediation might be a better option rather than going to a full-blown investigation. Now, the mediator will still, that will still be incurring legal fees for the TNRD, but far less than an investigation and a more alternative dispute resolution process rather than the investigative process. If the complaint is not dismissed informally, then the investigator moves to an actual formal investigation. And baked into the code of conduct is the authority of the investigator to speak to anyone relevant to the complaint, to request disclosure of documents relevant to the complaint, and to access any relevant TNRD documents subject to privilege that the TNRD may choose not to waive. Important to note, the investigator is retained by the TNRD. They are typically lawyers, and they are typically necessary to have legal training. And I know there's been items written about that in media. Well, why can't we have someone less expensive than a lawyer? And the answer is these things are complex. These investigations are complex. So, the investigator needs to know the Community Charter, the Local Government Act, the Freedom of Information Protection of Privacy Act, the judicial precedents and authorities and how these interact with each other. And it's just very difficult to foresee someone not having the legal training, be able to conduct these investigations, issue reports in a manner that will be upheld by the courts. And so for that reason, I actually don't know of any municipal or regional district code of conduct investigations completed by anyone other than a lawyer. And so following the investigation, the investigator will write a report which outlines the evidence and their findings, also their conclusions about the complaint, whether there's a breach, whether there is not a breach. If the investigator finds that a breach has occurred, they will make recommendations, and I emphasize recommendations, in their report as to appropriate sanctions. I say recommendations because the discretion always rests with the board. And there is a balancing that happens that we'll talk about a bit later when we talk about procedural fairness. So a board or a council, they're never required to follow the recommendations of an investigator. They preserve their own discretion to do what they wish with sanctions. Notably, however, if a board decides to go far in excess of what is recommended, there's a very good chance that there will be a legal challenge. And the court won't look at it as though, well, you didn't follow the investigator's recommendations, therefore you're offside, your decision's unreasonable. It's more of a gauge that when the investigator makes a recommendation, for instance, have some remedial training and maybe write a letter of apology, and instead the board comes back and says, we're going to suspend all pay and, a litany of other really harsh sanctions, it's an indication that perhaps that sanction may be unreasonable. And so for that reason, the board retains its discretion, but always, whatever sanctions they impose must be reasonable. So the board receives that report in a board meeting. This will usually, but not always, be enclosed. So there's no blanket necessity or even authority to receive and consider these reports in closed. You must still follow the regular rules in Section 90 of the Community Charter to close. Now, typically investigation reports will fall within that category. So typically it will involve personal information of somebody. It will also likely involve legal advice. So there are typically grounds under Section 90 to close the meeting while the board considers these, but not always. And for that reason, in the code, it shouldn't be specifying that they will always be held enclosed, because you won't know until the complaint comes before you. At this meeting, the respondent, so that is the person the complaint is made against, they have an opportunity to make submissions to the board in writing and in person at their discretion. The submissions are not focused on the evidence, so that is not an opportunity for the respondent to argue about the findings of the investigator. The purpose of their submissions at that point is to provide comments on what they think is an appropriate sanction for their found breach. And again, as I said, it is the board that retains the discretion to determine what those sanctions are. But ultimately, we do recommend against the board substituting its own views on the evidence. So an investigation is completed, the investigator provides a report. The board ought not to be saying, we don't actually like that evidence. We're not sure that that made sense. And it's not to say that you can't disagree with it, but if you do, then the step would be to order a follow-up investigation, a second opinion, something along the line, so that we have a procedurally fair process, rather than just jumping in and saying, well, we don't like that finding, we're going to substitute our own finding, because that again will expose the TNRD to judicial challenge. I will say, I missed the most important part, the sanction that the board does impose at that point. And that's just subject to consideration of the board, consideration of the recommendations made in the report, as well as the views of each of you and the views of the member about the substantiated complaint. So we've mentioned this concept of procedural fairness before, and it's really important to note that when a board hears a code of conduct complaint, considers an investigation report, and is determining sanctions, the board is sitting in its quasi-judicial capacity. So you sometimes sit in your legislative capacity when you're adopting bylaws. You also sit in your quasi-judicial capacity. Remedial action requirement hearings and considerations, code of conduct hearings, those regional districts that have business license enforcement powers, those are all quasi-judicial capacity. And when you sit in that capacity, you are akin to a court, and therefore the respondent, again, the person the complaint is made against, they have a right to a high degree of procedural fairness. So you act almost like a court, and the individual respondent has certain rights. So that will include things like they have a right to know the case they have to meet. They have a right to know all of the evidence upon which the board will be making its decision. So, for instance, there will be the investigation report, but there ought not to be, for instance, board members saying, well, along with that investigation report, I got all these emails and here's some more evidence. And what about these communications? Again, that's straying not only outside of the findings of the report, but that's not information that the respondent will have been made available to them. Things like advance written notice, the respondent must know when this meeting is going to take place. They must be provided with an opportunity to be represented by legal counsel if they wish. That's their own legal counsel at their own cost, but a board ought never to be denying a person the right to have legal representation. And as I said, they can present verbally, in person, or in writing at their discretion.
So now that Denise has walked you through the complaint process and walked you up to the point of this coming before the board with an investigation report for the board to determine whether sanctions should be imposed and what sanctions should be imposed, we're going to talk about those sanctions that are available to the board to impose on a member who has been found to have breached the code of conduct. So section 4.36 of the Code of Conduct bylaw sets out the sanctions, censures, and other corrective actions that the board can impose on a member for their violation of this bylaw. And it's important to note that these sanctions are only available for code of conduct breaches. Conduct that has not been the subject of a code of conduct complaint and investigation and report cannot be sanctioned for, because until a code of conduct investigation and report has been conducted, the conduct is only an allegation, not actually a determination by an independent investigator. So the board cannot sanction for things that are simply allegations and have not been found to have been true. So let's walk through some of these sanctions that are available to the board under the bylaw. So the first, of course, is a letter of reprimand. The board can also require that the respondent issue a letter of apology and can publish that letter of apology. The board can place conditions on the respondent receiving confidential records or information. The board can require the respondent to undertake mandatory training on TNRD business, the Community Charter, the Local Government Act, or this Code of Conduct bylaw. Continuing on, the board can require the respondent to take mandatory training on respectful workplace communications, can require the respondent to or place on the respondent restrictions on their access to TNRD facilities. The board can suspend or remove the respondent from board-appointed committees. The board can prohibit the respondent from representing the district at events. The board can prohibit the respondent from being reimbursed for attending conferences or seminars, and the board can reduce the respondent's remuneration in an amount and for a time period the board deems appropriate. The board can also refer the complaint to police. The board can issue a public censure of the respondent, and the board can impose any other sanction, corrective action, or other measure recommended by the investigator or that the board considers appropriate in the circumstances.
So now we're going to talk about what happens when a board member fails to comply with the sanction imposed by the board under the Code of Conduct. Section 4.39 of the Code of Conduct provides that if a member neglects or refuses to comply with any censure, sanction, corrective action, or any other measure imposed by the board, then the board may impose additional or alternative measures, censure, sanctions, etc., as set out in the list Kaylee just went over. Important to note, there doesn't need to be another investigation at that point. So a board would issue a sanction or other measure. The respondent fails to comply with that, then the board is free to up the ante, as it were, and say, okay, well, if you're not going to comply with that, here's our next round of censure, sanctions, or other measures. Turning now to the provisions of the Code of Conduct, which restrict elected officials from interfering with investigations under the code. So Kaylee mentioned that a little bit earlier. Legally, this is referred to as obstruction. And so the code specifies that board members must not threaten, interfere with, or otherwise obstruct an investigator in relation to the investigator carrying out their details under this code of conduct. Now, that's important for obvious reasons, that if a board member is using their position to intimidate staff or even other board members, you're not going to give evidence in this investigation. That's clearly inappropriate. Or trying to convince others to not participate in the investigation. That kind of conduct is prohibited under the code. Importantly, the code also states that board members must not threaten or undertake any reprisal against the complainant or any person who provides information to the investigator in the context of the complaint. So similarly linked to obstruction or interference, if the individual does participate in the complaint, then board members can't attempt to subject them to reprisal or other forms of punishment for participating in the investigation. Similarly, and importantly, the board members are all prohibited from filing complaints for a vexatious or malicious purpose. Now, I know nobody in this room would do that. We do see an importance in those provisions as we come into election periods, and that's at provincial, federal, local levels. When people launch their election campaigns, things can be said publicly that may cross the line. But certainly filing vexatious or frivolous complaints is something that's not permitted under the code, and itself can be the subject of a sanction. If a board member interferes with an investigation or engages in any kind of reprisal against complainants or witnesses, or they file this type of vexatious or frivolous complaint, the board can implement sanctions against those individuals.
So now that we've walked through, the board receives an investigation report, maybe imposes sanctions based on the recommendations of that investigator, what happens after that? We're going to talk about the board's release of code of conduct investigation reports and sanctions that have been imposed on an elected official as a result of a code of conduct complaint. So the code of conduct bylaw sets out that within 30 days after the board has reviewed the investigation report and imposed the appropriate censures, sanctions, and corrective actions, the TNRD will release a complete or redacted copy of the investigation report, or a summary if a complete or redacted copy is not possible, along with a description of the sanctions the board has imposed on the respondent. And these provisions are important for public accountability and transparency. And the bylaw specifies that any release of this information must comply with the TNRD's obligations under the Freedom of Information and Protection of Privacy Act. Moving along, we'll talk about the provisions of the code which allow board members to apply for reimbursement of legal fees incurred to defend themselves during a code of conduct complaint. So a board member who is accused of violating the code of conduct bylaw may be represented by a lawyer during the complaint investigation and sanctioning process, like Denise said. So under Part 7 of the Code of Conduct, a board member who incurs legal fees to respond to a complaint that has been made against them may request reimbursement from the board. And this is one of those procedural fairness provisions like Denise touched on before. The board's authority to provide this reimbursement is entirely permissive. The board can allow or disallow such reimbursement based on the circumstances of each complaint. And the board can also permit reimbursement on certain conditions. So for example, the board could allow reimbursement up to a certain amount, or could require the elected official to repay the amounts of legal fees if the investigator finds that the respondent did in fact commit a breach of the code of conduct.
So the key takeaways from the code of conduct, it sets out the standard of conduct that each board member expects of themselves, of this as a group, of their committee members. If a board member fails to meet the expected standards of conduct, a fellow board member, committee member, or staff can file a complaint against them. Importantly, this code does not allow members of the public to file complaints. That is an option for this board to consider. However, our experience has been that that becomes prohibitively expensive very, very quickly. If you allow any member of the public to weaponize a code of conduct, you can incur tens of thousands of dollars in investigation fees with very little that you can do about that. So for that reason, we've started with the assumption that public members of the public will not be allowed to file complaints. The code, of course, as we went over, provides a process by which the complaints are received, investigated, and then reported on. And this all ensures procedural fairness so that if it is challenged, if an individual respondent does make a complaint to the courts, bring a Judicial Review Procedure Act challenge, we call them, that hopefully, if the rules have been followed within the code, that decision of the board will withstand judicial scrutiny. If the investigator finds that a member breached the code, the board may impose sanctions that it deems fit. It can consider the recommendations, it should consider the recommendations made by the investigator, but it does retain discretion to impose whatever sanction, censure, or other measure that it deems appropriate. As Kaylee stated, and I believe I did earlier too, these provisions are becoming fairly standard across not just British Columbia, but across Canada. I've been practicing in this area for about 30 years. There never used to be codes of conduct. They just didn't exist. They would exist for staff on the administration side, but not for elected officials. Slowly, they became more prevalent, but even then it was, to a minor degree. And then once the province introduced legislation requiring councils and boards to at least consider codes of conduct, and if they decided not to adopt them, then explain to the public why that is that they were not adopting them, and further consider whether to adopt it again closer to the election. Once those requirements came into place and UBCM and LGMA provided sort of template, here's suggested code language, then they became more standard. And we saw at the same time provinces like Alberta and Ontario and Saskatchewan, some of the Maritimes, adopting similar requirements for codes of conduct. And so, as we stated, the TNRD's not recreating the wheel here. You're not out on a tangent doing anything different than any of the other local governments are doing. It's all about creating sort of standards of expectations and standard processes to follow when those expectations are not met. And if everybody, all the board members are aware of the standards expected, then we have more predictability, transparency, and responsibility in governance. So with that said, I know that was a lot of information. Trust me, it was a lot better than putting a 40-page bylaw in front of you to read through on a line by line, but nonetheless, it was a lot of information coming at once. So we're happy to answer any questions you might have.
Okay, so we thank you very much for that presentation, and thank you for laying it out so clearly. And thank you for the interesting background that up until a few years ago, codes of conduct did not really even exist as far as we're concerned. And now we're reviewing this for the third time in how many months? I'm just gonna, a question. I know that up until now, it has been voluntary for local governments to decide whether they want to adopt a code of conduct. The province is bringing in legislation that will force or that will require local governments to do a code of conduct, or are they talking about it? And then the corollary to that is, will the province be issuing sort of their own guidelines as to what must be in a code of conduct, the same way that they say these items must be on an agenda, and then you can add other things to it if you want to. So just maybe if you could just talk about, are we going to be reviewing this in a few months because the province has now imposed stuff?
Thank you, Chair. So indeed, the province is considering the matter, and the province has committed to bringing legislation in the future, although it has not committed to any dates, and in fact has said likely won't be in this term. Having said that, they are considering whether to make it mandatory, which in my view they will. That will come. I think that was always going to be the plan. They had several years of discretion to consider whether to adopt one. They're going to make it mandatory. As for mandatory language, difficult to say where they will land on that. There is always this tension with local governments wanting to preserve their own discretion and not be told by the province, what to do outside of the legislation. Having said that, there has been a push to have more standardized code of conduct language. So whether or not the board would be back considering next term, considering different language, it's possible. However, this is based already on sort of recommended provisions by UBCM and LGMA. Presumably, hopefully, if the province requires mandatory provisions, they would be consulting fairly heavily with UBCM and LGMA. So I don't expect it would be substantively or substantially different than what's in this, but I could be proven wrong on that point. But likely any amendments are a ways away.
Thank you. All right, I have Directors Blackwell, Thorpe, O'Toole, Middleton, and Karpuk so far. If I did not name you and you want to speak, put up your hand. Director Blackwell.
Yeah, thank you. Just on vexatious complaints, is that a legal bar, sort of a personal judgment bar? What's the bar for determining whether or not something is a vexatious complaint? And I have one more after that.
Excellent question. So it is definitely subject to a legal consideration. Now, when the board at the initial stage considers, is this vexatious? Our recommendation would be you get legal advice on that decision because there is a large body of case law on what vexatious lawsuits are. Not a huge body of law yet on what frivolous or vexatious codes of conduct complaints are. Yeah. Well, hopefully not, but yes. And so the investigator will have legal training on determining what is frivolous and vexatious.
Okay, and the second question, quickly, many of us have professional social media accounts, but also have personal social media accounts where we make comments that may stray into our professional business. Does this code of conduct or legal differentiate between the two?
So the bylaw itself applies to any comments on social media accounts that you have admin control over. So it would apply to both your personal and your professional facing accounts. Yes.
Thank you.
Just by way of example, sorry to jump in, just by way of example, you wouldn't want a member to be able to shield themselves, to, use their personal account to say a bunch of defamatory statements about their colleagues, et cetera. And the board have no discretion to wade into that simply because it was on a personal social media account. As Kaylee said, it's all about the control of that account.
Thank you. Director Thorpe.
Thank you, Chair. Actually, mine kind of go along the lines of Director Blackwell. So we hear a lot in the media about things like slap suits. We hear a lot lately about weaponizing codes of conduct and terms like psychological terrorism being thrown around. My daughter. So if we go back to this complaint process, and if there is no breach or it's found to be unfounded, what happens here? If it's gone to an investigator and then, like I say, it's found unfounded, does it just disappear under the rug? Or is there some way of this being transparent so that everybody knows what's going on and it's not used for weaponization?
Thank you, Director. So a couple of things in there. We've drafted the code in a manner that tries very much to avoid that weaponization of the code. That's why those off-ramps are built in at various stages so that the board and the TNRD is not committing itself to a full-scale investigation when one is not warranted. In terms of what happens if a complaint is not substantiated, this is again a difference from the prior code that the entire investigation and complaint process remains confidential unless and until the board has considered an investigation report finding the complaint substantiated. So if a complaint is not substantiated, I wouldn't use the term buried under the rug. It just remains confidential and it's closed because, for obvious reasons, just because somebody alleges something that shouldn't necessarily be made public. If it's found that that's not substantiated at all, then that stays confidential. And so those reports will not be published, and confidentiality is maintained.
Supplemental then, can something be built in that if the person is found to be it's found to be unfounded, that's not the right wording, that they have the opportunity to actually bring that forward if they choose to do so? Because I can see this being weaponized. If you've got somebody making complaints continuously, that it does go into that psychological terrorism and weaponizing.
I would say that built in to the code is already the provision that if the complainant is found to have lodged the complaint that is frivolous or vexatious or made in bad faith, to weaponize it, then yes, this board has discretion to wade into that territory. Again, because the process remains confidential, the weaponization it's difficult to foresee any real weaponization because it remains confidential, other than the time and energy put into responding to complaints. And I do acknowledge that could be an issue if that was done repeatedly. But again, the investigator does have the discretion and the authority to find that the complaint itself was frivolous, vexatious, or made in bad faith, in which case can make a recommendation, and the board has discretion to impose a sanction on the complainant.
Thank you. I have Directors O'Toole, Middleton, Karpuk, Sarai, and Bass. Director O'Toole.
Thank you very much, Chair. And thank you for your presentation. I just had kind of two parts. Just going back to you had discussed the idea of what could be considered by an investigator at the point of complaint. So when something reaches that benchmark that an official complaint has been filed, is there the ability to consider materials outside of the specific complaint, but say related to the subject matter? So things reach, because often in any situation, there can be a series of smaller things happening on an ongoing basis. In this case, I'll pick on the CAO, where the CAO is having, official emails back and forth with a director, let's say, over certain things that might be kind of blurring the lines, but aren't quite reaching the point of an official complaint. Now, on related matters, but a separate incident, there's an official complaint submitted. Can that behavior that's been ongoing, that may not have ever reached complaint level, but shows to kind of a pattern, an attitude, and intent, can it be considered in the investigation and in the available sanctions?
So in short, maybe. Really, it depends on relevancy and whether it's material. And that would be exactly the kind of thing you would want to mention in the complaint. So a board member has been bullying, harassing, acting inappropriately toward a staff member, and there is a history of inappropriate dialogue, inappropriate conduct. That would actually go into the complaint too. And the investigator would consider that evidence and determine whether or not it is relevant and material to the complaint. If there is a pattern of mistreatment that's disrespectful, but maybe on its own didn't rise to a level warranting a complaint, but it builds up over time, at law in an employment context, that is all relevant and material to any kind of investigation that happens. So for the most part, it would likely be considered by the investigator, but again, important for the complainant to then provide that information in the body of the complaint.
Okay, thank you. And then supplemental that, just kind of, so we're just looking at this whole series of sanctions, and we've seen, as we talked about and the chair mentioned, was these kinds of things have only been getting discussed publicly and codes of conduct coming in the last few years. And recently we've heard the minister, provincial minister, talking about them potentially adopting some of their own policies. And we've seen in certain areas of the province where in local governments, effectiveness of the local government becomes heavily impacted when one or more individuals is being caught up in this type of stuff. Do we anticipate that under new provincial regulation, maybe in the next term, that we might see to a point where the province takes control where they would get the ability to remove an elected official in order to try and allow those governments to be able to work and be more functional, because obviously at no point in any of this is that going to happen. That individual's still there, potentially causing a distraction, potentially putting a lot of burden on staff resources.
Thank you, Director. I wouldn't want to speculate as to what the province will eventually hand down in its legislation. A few things important worth noting that constitutionally and legislatively, right now, local government councils and boards have no authority or jurisdiction to remove members or even suspend members. That doesn't exist in BC legislation. However, it does exist in Ontario. So that for suspension, not removal from office, because again, democratically elected people, very rarely should a body be able to remove an elected official. Having said that, the province is considering all options. So the province likely will consider things like recall, things like the province being able to remove elected officials. I know Alberta has preserved for itself and has in fact acted on the legislation to remove elected officials from office. But if that ever made its way into BC legislation, I would assume that it would be very narrowly defined. And I would also assume that UBCM would push heavily against the province having wide discretion to remove elected officials from office. I think if anything, that conversation would be more about suspension for short periods of time, or a provincial removal from office for financial safety issues that very narrowly defined. But again, that's pure speculation on my part.
Director Middleton.
Thank you. Just a question, and it does sort of tie around, and I think a few of us have obviously got similar questions or thoughts, particularly around the complaint process, because that is something that that looks like it sort of could involve everyone. So just a question is, should a complaint come forward and staff brings it back to the board because they, in their opinion, or they feel after consultation that perhaps this is vexatious or not warranted, that would then come back to a board meeting in closed, correct? That discussion of that complaint or that thing would be done in a closed meeting. Second part of that is the complainant and the accused in that particular complaint, do they recuse from that, or are they included in those discussions? And then my next question, if I could just ask, because you did mention that at this point in time, if a board made a decision that someone had, that a complaint was vexatious or whatnot, the board could then impose sanctions against the complainant for putting forth a vexatious complaint. In order to do, or if they wanted to impose sanctions, would a code of conduct complaint then have to be filed against that complainant before you could move to doing any kind of sanctions? Or would you just sit and say, well, it was, so now we're going to do this? I mean, like, does then a code of conduct complaint have to be filed by somebody on the board against the complainant? So I don't know if all that makes sense.
I'll try to address each of your points there. So yes, if a complaint is filed and staff do an assessment and they determine that this is on its face a vexatious complaint, the process is then that it comes to a board meeting. Whether that is a closed meeting, probably yes, because you'll probably want legal advice. And so it would be closed under that provision of the community or of the Local Government Act and Community Charter. And then at that point, at that meeting where the board is considering staff's preliminary assessment that this may be a vexatious complaint, the complainant, the board member who has lodged the complaint, would have a conflict of interest with respect to that discussion and would probably recuse themselves. The respondent would have the opportunity to make submissions like they would with respect to any kind of sanction meeting. So they would be able to attend and speak to, whether this was a vexatious complaint or not. And then they would recuse themselves with respect to the discussion. There is no requirement that that someone file a subsequent code of conduct complaint with respect to the lodging of a vexatious complaint. The board would at some future point upon giving notice, be able to issue sanctions against the complainant at a subsequent meeting, if that makes sense.
So it doesn't have to, you don't actually have to file a code of conduct complaint, but you could in another meeting, so a subsequent meeting, not that same meeting and not right then and there on the spot, you could bring forth impose a sanction of some sort against that complainant without it going through a formal investigation process. Is that correct, or am I hearing that?
That's correct. So at a subsequent meeting, after giving notice to the complainant that the assessment had been done, that it was a vexatious complaint, the complainant would be able to come and give submissions on that point, and council could make a determination at that time. Not at the initial meeting, because of course the complainant needs an opportunity to come and make submissions, but at a future meeting.
Okay, thank you. And just on there, and I don't believe there is, but I would just like to ask the question, and that is there a timeline on when complaints can be issued? Or, we're coming up into election. We know that this can be used as a bit of a political tool and whatnot. We've seen other cases where old social media accounts are dragged up from somebody's high school days or this or that, and then sort of thrown out there. We all have a past, and the new age now is a lot of that past is online. Is there any time frame or timelines given around consideration of code of conduct complaints being filed against, is it something from within this term, or can it predate term? Is there just a little process to sort of make sure that this is potentially not used to just basically drag up old stuff and try and make it new again?
Yes, so there's a provision in the bylaw which says that the investigator should reject a complaint if the complaint is brought more than 6 months after the complainant knew or ought to have known about the subject of the complaint. There is some discretion in there for the investigator, to extend that timeline if they deem it appropriate, but 6 months is generally the rule there.
Good to know. Thank you.
Director Karpuk.
Thank you, Chair. I'd say good to see both of you, but I'm not sure. I think we could have probably given this lecture ourselves from council. Joking aside, I'm wondering if you could address a couple of points of clarity, and then I have a couple of general questions. So on the clarity, with regards to each complaint, it's my understanding each must be considered as a singularity and not as a cumulative effect. So one and then another one and another one does not make an additive effect or a multiplication. So if there's a complaint against a certain member, then there's another complaint, each individual event is in itself an event and not to be considered cumulative. Or could you maybe explain how that works?
So if I'm understanding your question correctly, there can be multiple codes of conduct complaint with respect to one individual. They would be separate complaints if the behavior is different, right? So if the complaint is this member did A, B, and C, there may be 3 complaints with respect to different misconduct, alleged misconduct. However, another point here may be that there may be multiple complainants about the same misconduct. And so under this bylaw, if there are multiple complainants who have lodged complaints about one particular piece of misconduct, the bylaw sets out that the investigator will only conduct one investigation with respect to that misconduct. However, they can extend the basis of the complaint to incorporate the elements of all 3 of those complaints, but it is one complaint, if that makes sense.
I guess maybe for some more clarity on this from my perspective, when it comes to sanctions measures, censorship, that's where we can't go and say, well, because of that and that, we have to do this now. It's as each individual event the recommendations are for the complaint registered, not in remembering what happened before, and before that, each individual event in the outcome as recommended by an investigator is considered as a singularity. Is that correct?
Yes and no. So the way I see this is, for your background, well, you have this background, I'm sure, but most local governments use a particular investigator for all of their codes of conduct complaint, and this is so that the investigator becomes familiar with the particular code of conduct and how it applies, but also an investigator who receives 3 separate complaints about one particular board member can rely on their own investigations in prior ones in conducting that recent investigation and issuing their report. When it comes before the board for a decision with respect to sanctioning, though, the board is sort of bound by the investigation report before them. So you can't say, oh, well, 6 months ago we got this other one, let's pull that one out of the file folder and let's put that on the table now too. You're bound by the confines of that investigation report before you, but that's not to say that the investigator won't incorporate that prior conduct into their recommendations that they make before the board.
Thank you for that. So a couple of quick questions with regards to interference with investigations. We can't interfere, but how does that relate to non-participation? Because this is a challenge that has been faced by many governments across the province in discussions I've had with them. So how does this, because that seems like interference to me. If you're not participating, which may delay or drag this out, or potentially even compromise whether this can go forward. I'm just curious what this bylaw that we have before us and how that non-participation is viewed versus non-interference.
Thank you, Director. So yes, not participating in an investigation can be seen as a form of obstructing the investigation. So it's a difficult area because one cannot force somebody to participate in a legal process that may result in prejudice to them. That gets into difficult territory. Having said that, baked into the code, the board can consider, you know, the fact that the individual refused to participate and take that into account. Certainly, the investigators will always take that into account when they are providing their investigation report. They will note that an individual refused to participate, et cetera. And so that will typically be taken into account when they make their recommendations as well.
And if I may, Chair, just one more thought. As I was sitting at the bottom of the elevator today and reflecting on yesterday and some discussions that I've had about how the public has kind of interacted with elected officials, and that's, I think, why we've seen the drive in code of conduct across the provinces. There's been a public change in not only participation in democracies and how people behave and in a democracy, so to speak, elected officials included. I'm wondering if there's an opportunity for us as we look at this as a document for us as elected officials, but is there an opportunity for us to also have it when we have interaction with public, that you could have a proviso that says if you're going to interact with our staff, with our members of the board, that you could say, I'm going to check the box, I will be a good citizen, I'll behave, I won't, you know, cause all sorts of chaos, I won't, I don't know if you know where I'm going with this, but we see on the elevator that, you know, behavioral issues that people may have may result in their removal or prosecution. We have that stated right on the building here in multiple locations, but maybe electronically that needs to be stated, because I know many of us in this room have seen some very unbecoming behavior. And it should be as very simple that if you're going to interact with us, it should be civil, that it should be professional. No one raises a person that I've ever seen to carry on the way some of the people do in the world. So could we not investigate the opportunity for us just to have a little check the box? I will be a good citizen. I will be respectful in our discourse and things like that. If they don't, then we can just say, well, we're not going to deal with you. I'm just curious what your thoughts are into that.
Oh, were it possible to contain the misbehavior of members of the public. So there's a few elements to your question, Director. Always, elected officials have a choice of whether or not they wish to interact with individuals. That's always your choice. And so if you're receiving abusive, certainly threatening, that's a different category altogether. If you're receiving disrespectful, abusive, unproductive communications from members of the public, you do not ever have to engage as an individual elected official. Having said that, the rules are different for the board as a whole when it acts in its governing role and the local government, the corporation of the local government. For those of you that were present for our SILGA presentation on ruling the unruly, we went through some of that. We are seeing just unprecedented bad behavior from members of the public, sometimes crossing into the line of threatening and criminal behavior. And unfortunately, again, setting aside threatening criminal conduct, just misbehaving, abusive, defamatory language, the courts have said in the past that as elected officials, you are expected to tolerate a higher level of misbehavior in the form of defamatory words from the members of the public. That comes along with the office. To a point, I mean, that's not saying you can't sue individually for defamation. You all retain that ability individually. But in terms of what the board can do or the corporation can do, they are bound. People are entitled to participate in their institutions with their institutions. And barring them from the facility, prohibiting them from speaking, restricting their contact, those can all be considered to be breaches of the Charter of Rights and Freedoms. So individually, yes, you can just decline. You've been rude, disrespectful. This is no longer productive. I'm not responding to your emails. You can do that. The board and the corporation is more restricted.
Chair, if I just supplemental on this, I'm thinking we're also the employers for our staff. And how do we protect our staff from people who may be doing the same thing in their interactions with staff? Is it not possible to have a bylaw that says, if you're going to interact with our staff, it must be respectful, it must be productive, and that sort of thing? Is that not a possibility?
So different issue altogether. This is again, one of the fundamental dilemmas that local governments face. That on the one hand, they have a statutory and common law obligation to protect their staff members from members of the public. It's just like any other form of an unsafe workplace. And that's a very low threshold. Name calling, rude language, aggressive language in any form can be seen under WorkSafe legislation as abusive to staff, bullying, harassment, and unsafe workplace. But at the same time, the board has a duty to preserve that individual's freedom of expression rights. So one incident can be both an unsafe workplace, make an unsafe workplace for the staff person, but also be preserved as a charter right for that person to be able to say those things. It's a fundamental dilemma that local governments are in right now. And that's part of the push on the province has been to get us some better legislation so that we can protect staff in those incidents. The short answer is we don't like to see that in a bylaw, that this is how the public must behave, because again, you're just inviting a charter challenge. We've seen local governments try to do that. We have seen interest groups challenge that based on a breach of charter protected expression rights. So the answer really is you empower your staff to disengage from those. So in an open meeting, abuse starts flying, staff are encouraged, know that they're empowered to leave the room and disengage, know that they are empowered to cease email communications that are repetitive bullying and harassment. Right now, that's the best that we have.
Director Sarai, and then I have Director Bass.
Thank you, Chair. Thank you, Council McCabe. Just a question, and this was put to me at UBCM, and I think it's come across our emails in the past very vaguely, but I don't have the answer. Can the members of the public, can the board or council take a code of conduct on behalf of a member of the public and bring it forward?
I think this is a bit of an interesting question because, again, it's a yes and a no, which is that if someone from the public comes to you and says, this conduct by this elected official was I see it as problematic. I think it's a breach of your code of conduct. You can assess that behavior and say, you know what, I actually agree and I'm going to launch a code of conduct with respect to that behavior, complaint with respect to that behavior. But the member of the public isn't the one launching the complaint. So you can sort of be a sounding board, right? Members of the public can bring their concerns to you and you can do your own sober assessment about whether you agree with that assessment on their behalf, but it's your complaint. It's not their complaint. So it's a bit of a yes and a no. It's not set out in the bylaw that members of the public can bring complaints through elected officials. It's just that they can raise their concerns with you in an informal way and you can lodge a complaint if that is how you feel.
Director Bass.
Can't believe I've got a question on this. Confidentiality continues when you leave a council or a board, right? So how does the code of conduct apply should someone leave the TNRD board and then break confidentiality? What's the remedy there? Because it's obviously not this bylaw. Not that I'm planning on doing it.
Thank you, Director. So the community charter, the code of conduct provisions mirror those of the community charter. And so the community charter expressly states that that confidentiality is maintained even after the individual leaves office. Now, what can the board or the council do? Limited, except that it's built into the legislation that if the local government suffers financial loss or harm as a result of that breach of confidentiality, and that could include legal fees defending against some sort of suit, then that individual can be personally liable for the loss or harm suffered by the local government.
So just a supplementary, when the corporation then have to go to court? Okay, and so then they're obviously incurring legal fees. Okay, thanks.
Anyone else have questions on this? Anyone else? All right, we do have a recommendation which has neither been moved nor seconded. Director Bass, seconded by Director Sarai. Thank you very much. Any discussion on the recommendation? No, everyone consents that I'm going to call a break after this, so no one wants to put their hand up. All right, on the question then, all those in favor? Anyone opposed? That is carried. Thank you very much for the presentation. And just before we do call a break, while I have your attention, Monday is the last day to submit your CAO survey. We have had 16 full responses, which means 11 directors have not completed the survey yet. We do have 3 partial. If you're one of the partial people, then you can go back and revisit. Perhaps you got interrupted, your cat jumped on your keyboard. It happens, allegedly. And so we can go back, but Monday is the deadline and 16 of the 27 have completed full responses, and we'd like to see that get up to 27 out of 27. So 10-minute break. Thank you very much.
Just
the most economical transportation methods. So we've added in some clarity that road conditions and safety are practical reasons for either extending accommodation or selecting another mode of transport. Further to that discussion in the March Policy and Governance Committee meeting, we also clarified some language in section 2.4 and 2.5 that speaks to extenuating circumstances in which a director may not be able to attend a conference and still request to receive remuneration or his expenses covered, his or her expenses covered for that trip if there is a legitimate reason for that missed travel. So those two changes have already been reviewed with the Policy and Governance Committee. We added in a couple additional things that I wanted to flag for folks. One additional add was a section 2.6 to clarify that the TNRD is tracking and reporting expenses in line with legislation. And the other piece that we wanted to add into the expense policy is around external committee expense reimbursement. This is currently being done by some directors on external committees. So where external committees provide their own reimbursement for expenses, we would have the expense policy suggest that those directors have to get reimbursed from the external committee first, where those external committees provide for reimbursement. So some of these external committees are committees that we fund. We're funding them to provide for reimbursements, yet we're still paying for some reimbursements ourselves. So we're wanting to make that clear, and that directors that are serving on external committees where the external committee terms of reference provides for expense reimbursement, the expense reimbursement will take place with the external committee. So those are the changes in whole that we're recommending for the board expense policy.
Thank you. We do have a recommendation. Director Bass, thank you. Seconded by Director Thorpe. Any discussion? Any questions? No? On the question, then all those in favor?
Aye.
Is anyone opposed? That is carried. Item 4.3, Board Remuneration Bylaw. We have a report here from General Manager of Corporate Services. We do have a recommendation.
Move the recommendation.
Corporate Officer Jeremiah. Oh, okay. Okay, so we are looking for any recommended amendments to the draft Board of Directors remuneration bylaw. So do we have any comments on the report, or just go right into it?
I don't think we got a seconder on moving the motion, sorry. I'm going backwards.
Okay, moved by Director O'Toole, seconded by Director Thorpe. Okay,
Sorry
All
about
right.
that confusion, that was ours.
that's okay. All right, so now, is there a report or presentation, or do we just jump right in?
Through the chair, I have nothing in additional, again, specific. Maybe I'll just clarify the intent of bringing the board remuneration bylaw forward for review today is not to approve or review any specific increases. It is a part of our regular review requirement for the remuneration bylaw itself, just to see if this is working. When we last reviewed the remuneration bylaw, we built in language that it would be reviewed every 2 years and ideally the year before election. So this is that regular review timeline. You can see we've made small recommendations for updates. And one is simply to update the table of remuneration to the latest available remuneration amounts from January 1st, 2025. We have aligned section 12 with the new board code of conduct bylaw or policy. And again, we've talked about the external committees providing expenses and remuneration through external committees when there is that in the terms of reference. So very minor updates overall recommended to the remuneration bylaw.
Thank you. Does anyone have any questions or comments? Does anyone have any concerns? Director Blackwell.
Yeah, it's nice to see in the chart that we are, close to the median and the average, sort of across the province with regional districts. It's nice to know that we are paying attention to that and we're sort of set in that middle ground area, which is great. Considering we have a board, the largest board other than I believe Metro Vancouver, which is not on this list in the province.
Thank you. Any other questions or comments? All right, on the question, all those in favor?
Aye.
Anyone opposed? That is carried. 4.4, Board of Directors Procedure Bylaw Update. We do have a recommendation. Director Sarai, seconded by Director Blackwell. Thank you. All right. Corporate Officer Jeremiah.
I do have a presentation for the board just to detail the recommendations. Okay, so staff are presenting the sections of the board procedure bylaw for feedback and discussion. This also gives the board members an opportunity to identify areas they feel require amendments. So prior to amending or repealing the board procedure bylaw, we must provide notice in accordance with section 94 of the community charter. And a finalized board procedure bylaw will be brought forward to a future meeting for consideration and then adoption at a subsequent meeting following that. So the last review was done in 2022 to reflect increased efficiencies. This included amendments to electronic meeting provisions and provided alignment with updates to the Local Government Act. Supports the governance process so that the public, board, and staff understand how decisions are made and what to expect at meetings. It's a living document and it will be amended to ensure that it meets the needs of the board, public, and evolving legislation. The proposed changes are intended to address gaps and align existing practices with a clear set of rules and procedures outlined in the bylaw. So the proposed changes, local governments are required to provide notice in accordance with the Local Government Act and the Community Charter to provide advance notice of certain matters of public interest and allow for participation in local government decision-making. In 2022, the legislation changed to allow governments the ability to adopt an alternate means bylaw to provide alternate means of publishing public notice. This is necessary as it will provide increased flexibility, accessibility, cost savings without the publishing deadlines. It's also beneficial in rural areas where newspaper advertisements are unavailable. Following the adoption of the board procedure bylaw, we will be bringing a new alternate means of notice bylaw to the board for consideration, which will allow for the TNRD website and social media to be used as an alternate method of providing notice. Section 7.2, election of chair and vice chair. It's a minor modification to allow for consistency for board and committee elections and ensure leadership continuity, procedural integrity, and maintaining the structure and flow of the meeting. So this is just to say that the chair presides immediately following the declaration of the election results for the position of vice chair. Sections 14 and 15, disqualification for failure to attend meetings. This is just added for clarity and awareness for board members. Section 204 of the Local Government Act stipulates that board members shall be disqualified from holding office if the member is absent from the board meetings for the longer of 60 consecutive days or 4 consecutive regular meetings. Additionally, we've included 4 committee meetings, 180 consecutive days, or 6 consecutive regular scheduled meetings of the committee. It's important to note that disqualification will not apply if due to illness, injury, or leave of absence. Section 17.9, delegation reports, and the recommendation, we're adjusting the unapproved delegation report to be annual rather than semi-annual to align with current practice. Delegation reports are only required in the board procedure bylaw when a delegation has been rejected. As rejected delegations are not a common practice for the TNRD, staff recommend a report to the board annually to ensure a more efficient practice. So we're not just coming to you guys if we have one. Section 21, question period. Our recommendation is to reduce the time spent from 15 minutes to 10 minutes to align with best practice. And additionally, each speaker has 2 minutes to pose questions regarding items on this agenda. This has been a topic of conversation amongst many local governments due to disruptive behavior by members of the public. As the board meetings don't see a large participation from the public, staff are recommending reducing the question period to 10 minutes and clarifying that each speaker will have 2 minutes to pose their question regarding an item on the agenda.
If I may, just a question here. I know that this has been a point for other local governments, with some members of the public interpreting an item on the agenda to mean if it was included in the minutes from the previous agenda. So if an item formed a part of our discussion, our board meeting on September 11th and is encapsulated in the minutes, which are attached to the agenda for yesterday, the October 3rd meeting, people are interpreting that as, no, you're not discussing this on the October 3rd meeting, but it is on the agenda. So is there any way that we can clarify that they don't get 2 bites at the cherry, as it were? If it's in the minutes from the previous, technically it does form part of the agenda, but it's not on the agenda because we're not talking about it.
I would be happy to include language around that.
Thank you.
Section 22, new business. This is to provide additional clarification on the process for adding items to the agenda under new business. So staff have conducted a review to understand how each regional district handles new business. Some follow a similar process to the TNRD currently, and others, their process was very unique to their organization. While the current board procedure bylaw details the process for handling new business, there hasn't been consistency with how items raised under new business have been addressed in meetings. The intent of this is to align with the procedure set out in the bylaw, and staff have provided additional clarification with the intent to provide a more consistent process moving forward. So the recommendation is that verbal reports are accepted under new business by any directors. Items of a complex nature affecting TNRD bylaws and policies shall be introduced as a notice of motion, which is current practice. Anything requiring additional staff time would be introduced under a notice of motion. Proposed resolutions or motions pertaining to a matter not on the agenda will be introduced under additions or deletions from the agenda for consideration under new business. So we're just streamlining the process and ensuring that we're adding items to the agenda when they haven't been previously introduced.
So just for clarification, a verbal report would be something like the Monty Creek Fire Hall opening last weekend was awesome. 150 people attended and it was a great turnout and we're so happy to see it.
Correct.
So you don't need to provide anything in writing. You're simply, okay. And then items of a complex nature. Now we get into kind of the gray area, proposed resolutions or motions pertaining to a matter not on the agenda. Can we stipulate that if it is a proposed resolution, a proposed motion, so why would that not be a notice of motion?
A proposed resolution, if it's something like a letter of support or something that's not requiring, it's not complex, it's not requiring a report, like an official report that needs to be returned to the board at a future meeting, I think we can introduce that under new business or through the additions or deletions to the agenda. We can include wording to require that this resolution be provided in writing to all board members in the blue folder, something along those lines, so that everybody is aware of it ahead of time.
I think because, I mean, we have talked at this table about the different people absorb information in different ways. Some people are very good at processing it orally. Some people need to read it in time and to consider it. I know Director Lepso has, I believe quite rightly, brought this up several times. I think people, if people are at all uncertain as to how much work would be involved, I think they need to talk with staff first to see, is this something I can bring up under new business or is it a notice of motion? And I think some language regarding providing a written summary, a copy of the letter that you want to send, or as Director Houghton did yesterday, a copy, you know, I'd like us to send something like this. I think some language surrounding what people have to do rather than just getting up and then saying something very complex and a lot of people are going, well, I'm sorry, what are we asked to vote on here?
And staff are more than happy to help directors craft a resolution prior to the meeting to ensure that we can have this added into the blue folders if that is what the board wishes to have added to the procedure bylaw.
Thank you.
Section 24, closed meetings. As electronic meetings frequency has increased over the years, staff felt it necessary to ensure confidentiality is being met for all closed meetings. Board and staff members attending a closed meeting via electronic means will need to verify that they are alone prior to a closed meeting discussion, and this statement will be recorded in the minutes. Closed meeting matters must not be released without resolution, and this adds an additional measure to ensure that what happens in closed stays enclosed. So we will just, as I had said, the member will declare that they are alone prior to the start of the closed meeting, and their statement will be recorded. This was a question that was requested a while back regarding points of order. So we're just adding additional language to clarify the process for members to raise points of order. I think it's pretty cut and dry, I think, with the chair's ruling and how these measures will be addressed. Does anyone have any questions on this? Okay. Section 30.6, electronic participation. We're just providing clarification and consistency around the maximum number of meetings a director may attend electronically. We've increased this number from 2 to 4 meetings. There was inconsistencies recognized, particularly between the public hearings and regular board meetings, as these are recognized on one agenda, one agenda package. Having a public hearing limited to 2 meetings, and you can attend 4 meetings as electronically for a regular board meeting. It just didn't work out. There's a lot of inconsistencies there. So we've brought them both together to reflect 4 meetings and then did the same for the committee of the whole. Yep.
Is that just a typo one where we go for commission and then it goes to for in bracket?
Oh.
For is the to an extra word?
It is a typo. I apologize.
Thank you.
Director Blackwell?
Section 31, electronic access to public meetings. So this is to include language to clarify expectations for publicly available recorded meetings. So the minutes of each meeting are the official record. The TNRD has never set a time limit to recordings being hosted on the TNRD YouTube page. While there is no requirement in legislation to post the recordings, the majority of local governments follow the same practice and publicly post on their website through their meeting software or on various public channels such as YouTube. Communication staff have reviewed the analytics for the TNRD YouTube channel and noted that the majority of traffic is seen within the first 48 hours of posting. After 7 days, the spike in traffic evaporates and views trickle in for the remainder of their life. Staff are recommending that videos remain on the TNRD YouTube page for a period of 1 year, and then copies of all meeting recordings will continue to remain in the custody of the TNRD. Last but not least, section 34, committee appointments. So this provides additional clarification and consistency with the current practices regarding the appointment of external and advisory committees. Standing and select committee appointments remain under the chair's purview as required under legislation, and the board will appoint members to external and advisory committees. Staff recommend committee appointments continue to occur every 2 years at the first meeting held in January. our next appointment will be held in January 2027. And this will allow board members to become familiar with the process conducted by the committees and allows for knowledge sharing with their peers and constituents.
All right, thank
Feedback or
you.
questions?
Director Grenier is first off the mark, and then Director Karpak. Director Grenier.
Thank you, Chair. Thank you. This actually goes back to the previous question. You said that the videos of the meetings would be held for 1 year. Are you suggesting that you destroy the video after, or is it retained? Because I'm thinking that things that came up in previous years might be useful to the existing council or the subsequent council for reference. I'm thinking when we dealt with a matter very recently, people couldn't explain what took place 20 or 30 years ago, and it would have been so useful if we had that understanding. So I'm just thinking, can we retain these things indefinitely since they occurred in real time?
The intent is to have the minutes as the official record. So these are going to be removed after 1 year publicly. The record of the meeting, the recording of the meeting will still remain with the TNRD. So it'll still remain in our files. We can always go back to it if we need to research something, if something needs to be looked up. But it's just that the viewership is not there. It's not required, usually not required following 7 days after the meeting's been posted. So housekeeping item, essentially.
So supplementary, it goes without saying then that there's no intent to destroy the record after 1 year. And we don't need to clarify that we retain them for some time period, or?
They will not be destroyed. They will remain in the custody and control of the TNRD. So they are a living document, or not a living document, but they will be retained in our files.
Thank you. I have Directors Karpak, O'Connor, and Blackwell so far. Director Karpak.
Thank you, Chair. I'm wondering if it'd be possible to go back to the committee appointments, I think 35.1. The chair will make standing and select committee appointments. That seems in contravention to what the acts state, where the committees of select status are actually at the board's discretion, not the chair's. Not that I
I
know
would have
that for any
to-
reason, but
I would have to look that up. We've always
I
communicated.
just looked at it and it looks like this is different than what the legislation states. So standing committees being appointed by the chair of the board or mayor and council,
Mhm.
whereas the council or the board itself is responsible for select committees as they're a different constituent makeup. Just a point.
I will refer to that and make those changes. Historically, the chair is always appointed for standing and select committees. We don't have any select committees that we've been appointing. And it's always been communicated this way, but we can revise.
Director O'Connor.
Thank you. Item 21.2, the 2 minutes for questioning on the agenda. I'd just like some understanding of why it's at the end of the agenda and not at the beginning. I know our municipal agenda is at the beginning, and I just would like some clarification if you could explain that.
That's a very good question. I think it's at the preference of the municipality, our council, and the board. Historically, we've always kept it at the end. My thoughts would be that this wouldn't interfere with any decision-making processes in advance of the meeting. The board would have an opportunity to read the reports in advance and would be able to make their considerations based on that information. Items can be reconsidered during a meeting.
Yeah, I'm not suggesting one way or the other. I just would like some understanding. Thank you.
I think it's always interesting to me that the province or the community charter does set out what must be in an agenda, what has to be. Like, this is an a la carte thing. You don't get to pick and choose. You can add to what the province says has to be there. And one of the things the province does not say has to be there is a public inquiry session. Under the community charter, no local government is forced to or must have any kind of public input at its meetings. Any local governments that have added that have done it on their own discretion. And as I understand it, you could have three if you wanted. You could have one at the beginning, one in the middle, and one at the end. You don't have to confine it to items on the agenda. And every time I've had this discussion anywhere about should it be at the beginning or the end, you could really take all the arguments in favor of having it at the beginning and flip it around and do the opposite as to why you should have it at the end. So it's really the will of the board in this case, whether we have it at the beginning or end. The other thing, just interestingly, I've heard is 2 minutes. That's not very long. All right, you set 2 minutes on a timer and then just sit there and watch it, and it's an eternity. If you cannot ask your question in 2 minutes, you're doing it incorrectly. Director Blackwell.
Yes, unless you're trying to get everything you want to say into the health minister, then 5 to 9 minutes is not long enough. I am probably gonna open a giant mental can of worms here, and I apologize in advance. Thinking about everything that we have talked about today so far, how does it filter into what we do on the hospital board? Do we need to redo this work? Does it automatically apply? Is the hospital board a creature of the TNRD board?
The hospital board actually has its own procedure bylaw. This is something that we would need to revisit at the discretion of the hospital board. If that is something that they are interested in doing, we are more than happy to revisit that to make it align better with our existing procedure bylaw as well. I'll leave that to Chair O'Reilly this afternoon. Sure. It has not been, to be honest, it hasn't been updated in quite some time, so it may warrant.
Good idea.
Hospital board chair O'Reilly's informing me that it has been updated within the last century, so we should be good. I'll invite anyone else who has questions. I just have a question regarding, it's not really on one of the changes here, delegations from the public. We did have a delegation from the public 2 or 3 meetings ago, and there were a number of questions as to why that precisely was a delegation. Someone coming mostly to complain about a director. And I explained that as far as I could tell, there was nothing preventing them necessarily from being a delegation. Is this a risk of opening a can of worms? Is this something that and in light of our code of conduct discussion perhaps earlier today, is this something that we need to at least give consideration to, putting stronger language as to what does and does not constitute a delegation? I think up until fairly recently, it would have been understood it was an organization or group or business providing information about something they are doing in the community. And I think we are starting to see people using it as a general gripe session and a chance to come and talk sour grapes about the local government in question. Is that really a delegation? And do we need to, perhaps not now, perhaps after some more discussion, come up with some language around that?
I think we can research into this and perhaps even reflect on Ms. McCabe's presentation today, where the public is, I believe, given a forum to speak. But I think we can add some language to better describe what our limitations are, or how we're going to handle these requests.
Or perhaps some language then around what a delegation is intended to be. A delegation is intended to present information about an ongoing activity or business in the community. It is intended to provide information about an organization and what they are doing for the benefit of residents of the community. They are here to ask the TNRD for a letter of support, grant funding, whatever the ask is, but not saying a delegation is someone who's showing up to complain about a director. or complain about a decision, there are other avenues for them to do that, such as the public inquiry or public, if it's on the agenda, or even just contacting the TNRD separately. I don't know that we want to start opening up delegations as a place for that.
That one delegation was a unique request. We can look at other ways of dealing with these. The application form on our website for delegation requests does detail some information about the requirements for requesting to appear as a delegation. Grants, for example, like grant requests, would be required to go to the CFO. So we do have some information on there. We can also further clarify that so that members of the public are aware of the stipulations to appear as a delegation.
I realize the danger of formulating policy or bylaw around one event that has never happened before, but one swallow does not a summer make, but who knows what's the first swallow and how many are coming after it. And we are seeing lots of changes in expectations and the way the public interacts with elected officials. So yes, it's tempting to say that was a one-off and it'll never happen again. But then the next time it happens, we're going to wish we put something in our procedure bylaw.
We definitely don't want to set a precedence. So.
CAO Hildebrand.
Thank you, Chair. Just wanted to bring up, I know procedure bylaw comes up a lot over the last number of years with little things that we've talked about. So here's your time. When Director O'Connor brought up question period being at the top of the agenda, if you feel differently, tell us, because the whole point of the committee of the whole is to have this discussion. And because when we bring this back to the board for final adoption, it's done again. And I don't want to take the next 4 years to have issues with that. So just when it comes to delegations or question period, give us your feedback if you think differently, because we'd gladly make those changes.
And just I've got Director Middleton, I've got Director Lip. So reporter was here and asked about why we were doing the code of conduct changes now. And I said, I think it's prudent for local governments with a year to go to the next election to tidy house and tidy these things up, because when a new board or a new council is elected next year, they remember back to whenever it was that you were first at this table and how much you had to learn in a very short period of time. Would you have liked to be dealing with overhauling the board procedure bylaw within 2 months of first getting elected? I know I wouldn't. Or any of these bylaws, because they are complex. You need to understand what you're dealing with before you deal with it. So I think that we're doing a duty to the next board, whoever that is made up of, to get the house in order and get all these things tidied up based on our experience. And I expect that 4 years from now, so that's 2029, whoever is on the board then is going to be going through this same discussion. I'm hoping to get it in nice shape for their the people who follow them. All right, Director Middleton and Director Lepso.
Quick question back on question period, and my thought a little bit is if we're dealing with matters pertaining to the agenda and we're going to sort of permit this, question period, if you would like to call it that, or public input, which it could be named either or, I suppose, is, in my opinion, it should probably be at the beginning of the meeting, not at the end. And is there rules around electronic participation on public input? I don't know if there's any language or any criteria around that. We don't seem to have a lot of public participating in our meetings by Zoom, but do we even know if they're there or not? I'm not too sure how we determine, who may be sort of in queue or watching and may want to participate in that. Just a bit of clarification if we could.
So members of the public have the opportunity to attend electronically. They register in advance through Zoom. So we do have their registration. Justin does check on Zoom to see if any participants do have a hand up during the question period. So We are doing that double check to make sure that if there are members of the public that do wish to speak during the question period, they are given the ability to do so.
Thank you.
Director Lepso.
Yeah, thank you for addressing some of my concerns, and what some of the things the Village of Chase does is, my questions about adding things initially, like right before a meeting, is like we have a great staff. And I really like it when staff gets a chance to vet anything we put on the agenda, like I really appreciate. And we lose that by adding it at the beginning, we don't get. And sometimes things are added, we send something out, and then I find 3 hours later, well, it's already been dealt with, so we kind of look maybe not in the best form, right? Because we're asking for something that's already dealt with. So we actually allow a little more public notice unless it's a unanimous consideration. At the beginning of the meeting, we don't have a question, but we do have provide input, which I like because maybe someone, a member of the public actually has something that's relevant. So they're allowed to provide input, but no questions. At the end of the meeting, once a month, we do allow questions on any municipal matter, but we don't answer them. We just refer it to staff because we always like making board decisions. We don't have individuals answering them. And then the time issue, which I guess can all be run through our corporate officer. I'm just a layperson, but we have it that the board can extend the time to speak with a 4 out of 5 vote. So, but thank you.
I think a lot of it does come down, whether at the board or the council table, it comes down to the chair's discretion. You know, we might say we have a 10-minute time limit for questions from the public. And I mean, I'm looking at the empty public gallery right now. But there might come a day when we have 8 people there, each with a legitimate question. And then, you know, I think it would be a very churlish chair who would go, okay, it's been 10 minutes. Sorry, the rest of you don't get a chance to speak. So it is at the chair's discretion, and this is where it comes into you're looking at the tone, the flavor, how relevant are the questions. You know, there's a whole lot of stuff going through, and you're never going to get it right 100% of the time. But I think it comes down to that flexibility and not, you know, being able to know what the rules are. And in order to break the rules, you first have to know what they are. So giving them a little bit of a flexibility, there's a bit of wiggle room. Director Bass.
Thank you. Just because CEO Hildebrand wants to hear from people. I agree question period should be at the top because there's no sense in asking questions once we've made a decision. I desperately need printed notices of motion because like you, I'm a visual learner. And the delegation request for city restricts it to community groups and organizations to discuss their initiatives only. So that might be some guidance for us because I too was really upset about that meeting and that delegation. So that's just my part of this contribution.
So, Corporate Officer Jeremiah, if there is an appetite for discussion about whether questions from the public or public inquiries or whatever we call it comes at the beginning or the end, do we put our hands up? Does someone have to make a recommendation that we make that change? How does this work?
If you would like, with a show of hands, we can record that and make sure that we're incorporating that change into the revised board procedure bylaw to bring back to the board at a future meeting.
So maybe we'll just have a quick focus, any questions or comments on the location of public inquiries within our agenda. If anyone has any thoughts, yay or nay, whether it should be at the beginning or the end, and maybe one sentence as to why. If you were trapped in an elevator for 10 seconds with someone, what would your pitch be to convince them of your point of view? Director Sarai.
Thank you, Chair. I think it'd be better at the beginning if you have the public here instead of having them sit here throughout the whole meeting and having to weigh in on something we've already decided, like Director Bass said. Doesn't make any sense. Give them the opportunity to speak at the beginning. time is valuable on that other side of the bench there as well.
Thank you, Director Morris.
Essentially, I was going to say something similar. I think the beginning is a good idea. And then subsequent comments come at a different time. Thank you.
Thank you. Anyone else feel strongly about this? Okay, a show of hands then. How many people would prefer to see public inquiries at the beginning of the agenda? So that's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, including Director Newstater. So I'd say that then the majority are in favor of switching it to the beginning. Okay,
Thank you. We will make that change.
thank you. All right. Oh, Director Lepso.
Just to comment on that, would there be a time limit on that, or I can't remember?
I think, well, we're going with 10 minutes in total and 2 minutes per person, but that is subject to the discretion of the chair, depending on the tenor of the questions in the meeting. But that's kind of unspoken, although I just said it. I don't know. All right, I have no one else on my speakers list, but is there anyone else who has questions or comments? CAO Hildebrand.
Thank you for that, because that, excuse me, that was the feeling I was getting, is that the question period needed to be moved, and I'm glad we did that because we would be changing it again next term. So the other question I had is about delegations, and it sounds like the group is also wanting some language around what constitutes a delegation and what doesn't. Am I hearing the right thing? So, okay, so just wanted to make sure. Was there anything else? Direction on?
The corporate officer, I think, wrote down what Director Bass said around the language for the city of Kamloops. And Director Bass, can you just repeat that? What it
Community
says?
organizations, groups or organizations to discuss their initiatives and not ask for any money.
So there. All right. So is everyone comfortable with language around that it's for groups, businesses, organizations to discuss their initiatives? Director Sal?
Thank you, Chair. I just got a question about the current delegation process. Isn't there an application currently, how it goes? If somebody wants to be delegation, they submit an application and it's not an automatic approval. So what is the current review process at that stage? Can we target that stage?
Corporate officer?
Yes, we will be reviewing the application form and making modifications on there as well.
And I think the issue was that I certainly got a sense from comments that I had afterwards that a lot of people around this table felt that should not have been a delegation. And as I said, my response was, well, there is nothing currently in our procedure bylaw that prevents them from being a delegation. So I think that by putting using language similar to what the city uses when it comes to what our expectations of a delegation are, I think it will preclude that kind of a presentation in the future. And no, Director Sal, you're correct. It is not automatic. You have to fill out an application form and then it comes to staff, and then staff asks the chair to approve, delegations. I've never said no based on either the fact that, yes, this is a delegation, or there's no reason that we can prevent them from being a delegation under the rules as they stand right now. CAO Hildebrand.
Just one final comment on this would be that I think the other option for residents or folks to share what they feel would be through correspondence only then. If versus that delegation, that could have been written and sent to the board, but that would be the only way. And maybe there's rules around that too, but just something to consider.
Any other questions or comments? Director Middleton.
I think in that one particular delegation that comes to mind and that we've sort of discussed is that individual could potentially have gone to the public inquiry portion, tried to get a point across that way. It would then be up to our chair to shut that person down if they were not here to, they put anything out there, but then when they start to veer or start to turn their they're 2 minutes into a rant against somebody, then it would be up to the chair to basically shut them down. And so I think, there's always going to be potential that somebody's going to come as a member of the public or under the public inquiry section and, change their course partway through or whatnot. So I really think it's incumbent on the chair, and thankfully we have a strong chair that would shut those types of rants or accusations or whatever you might like to call them down right away, so that they don't, that inquiry section doesn't become used as a place to come at individual directors and or the TNRD as a whole in a disrespectful and unwarranted manner. So just my input, and thank you, Chair.
Thank you. Well, I mean, our procedure bylaw as it stands does give the chair the ability, obviously, if someone presents as a delegation and then they start veering off topic, or they start becoming rude, or they start becoming offensive or abusive, then the chair obviously has the opportunity to shut them down. And I think the same thing applies to public inquiries. You can very quickly tell whether someone actually has a legitimate question or concern, or whether they don't. And so it's just a question of I think, again, it's that flexibility. It's listening to, taking the temperature of the room and seeing where people are going, and just being able to step in and say, are you coming to a question here? And if they don't, they've got 2 minutes, and then they get hooked. Anyone else have any questions or comments? Last chance. All right, we do have a recommendation. On that recommendation, all those in favor?
Aye.
Anyone opposed? That's carried. All right, and there's nothing else on my agenda. So unless your agenda says something differently, we are adjourned. Oh, corporate
Sorry,
officer, saved by the bell. Corporate office.
I don't recall we had a mover or a seconder for the procedure bylaw. And I think we should,
I'll move the recommendation.
Apologies.
pardon me? Yes, please. As amended.
Okay. So the recommendation, the Committee of the Whole review recommended changes as amended in the draft board procedure bylaw, correct? All right, should we, just for the sake of doing it correctly, have another vote?
Sure.
Sure. Why not? Okay, all those in favor?
Bill, aye.
Anyone opposed? That is carried. All right, and now we have nothing else on the agenda, so we will be back here at 1 o'clock. All right, back here at 1 o'clock for hospital board.